member for Kooyong.
I move amendments 1 to 3 as circulated in my name together. Thank you, Mr Speaker. I'm grateful for the opportunity to submit this proposed amendment to the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill 2022. The landmark Jenkins report found that workplace sexual harassment is prevalent and persuasive. It occurs in every industry, in every location and at every level in Australian workplaces. This bill is an important and historic landmark on our path to a fairer, more equitable and safer workplace for all Australians. I applaud the Albanese government for committing to prevention of and addressing the consequences of workplace sexual harassment and other forms of discrimination. I also welcome the Attorney-General's comments this morning that this is just the beginning of a conversation on these matters, and I agree with him that reasonable minds may well differ on their execution. I remain of the belief, however, that the issue of cost provision as managed in this bill is problematic, and it's this which is addressed by the proposed amendment. Recommendation 25 of the Respect at Work report clearly articulates the need to ensure that fear of adverse cost orders does not create a barrier to victim survivors of workplace sexual harassment seeking access to justice. In passing this important legislation, we have to make it easier for victims of workplace sexual harassment to speak out and to receive justice. We must ensure that employers understand their responsibility to protect their workplace and their workforce and the ramifications of not doing so. The risk of adverse cost orders is clearly a disincentive to applicants considering pursuing sexual harassment matters in the federal court. The Respect at Work report proposed that costs might be ordered against the applicant only where the court was satisfied that the party instituted the proceedings vexatiously or without cause. That model has not been adopted in this bill. Instead, this bill proposes a cost neutrality approach, in which litigants bear their own costs unless the court orders otherwise. The bill does set out various factors that the court must have regard to in making cost orders. Superficially, the cost-neutral arrangement represents an improvement on the status quo. In effect, however, its design and the uncertainty around its operation will serve to undermine access to justice by limiting the availability of applicants to secure legal representation. Taking a cost-neutrality approach to a relationship characterised by systemic inequality only serves to entrench that inequality. The amendment I have proposed offers an alternative, an equal access approach. Under this proposal, each party will bear its own costs except when the applicant is unsuccessful, i.e. the cost has found that the respondent has engaged in discriminatory conduct, in which case the respondent will be liable to pay the applicant's costs, as they should be. You should not be excused from bearing costs when you have broken the law. People and organisations found to have engaged in discrimination or harassment in breach of the law should have to pay the legal costs of the applicant. This will act as an incentive to change workplace cultures that permit discriminatory treatment. This should apply not only to sex discrimination cases, but also to cases or instances of discrimination on the basis of race, age or physical capacity. As the government knows, an equal access model has already been adopted domestically for whistleblowers. In introducing this change to the usual cost rule, the Parliament recognised at that time that, and I quote, legal costs can be prohibitive to any person seeking compensation for damage, and the risk of being ordered to pay the costs of other parties to the proceedings can deter whistleblowers and other victims from bringing the matter to court. This reform will increase access to justice. People who have experienced harassment and discrimination will be able to take their case to court, and discriminatory behaviour will be appropriately penalised. There will be a flow-on impact to workplace culture. Each of the 7 recommendations being implemented through this bill is important and long overdue. Combined, they will fundamentally change how acceptance and respect are perceived in our workplace. But I urge the government to accept this proposed amendment to improve the path to representation in federal court.